Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tuloyan. So yesterday we saw that 174 application come and go with Judge Ratamukhatling ending up dismissing that application. But looking at his reasoning behind his rejection of that application, I have this feeling that the prospects of success on having this decision appealed right now without having to wait for the end of the trial are very good, because I simply do not agree with the logic that the judge resorted to in coming to that decision that he came to yesterday. So my feeling is something must be done about that decision, because I'm of the firm view that another court would come to a different decision, given the fact that I find that decision quite at variance with the facts as we know them. Because, for starters, look at the evidence against accused number 4, Mapisa. The flimsy evidence around the Makeleni issue, the Zungu evidence, and the so-called confessions. I think Judge Rata misdirected himself by coming to the conclusion that, because Zungu had testified that all accused persons had been seen or had been in his company at the hostel. So they had some common purpose to do something or to kill Senzo MEYIWA. But there doesn't seem to have been any discussion there about the killing of Senzo MEYIWA while they were having those drinks. So that is evidence which is rather shaky. Now, when I look at the entire evidence up to now at the close of the prosecution case, I ask myself, if that was the only evidence, because you see, there must be evidence which calls upon or warrants that the accused persons must come before court to answer. There must be some kind of prima facie case, a case that on the face of things, warrants an explanation on the part of the accused persons. And another issue is Judge Rata saying that at the stage of the proceedings, if that was the only evidence he had against Mapisa, would we then find Mapisa guilty of the murder of Senzo MEYIWA? Because in effect, that is what it means. He is saying there's a common purpose that runs through all the accused persons, so that the acts of the actual perpetrators equals the acts of even those who are sort of peripheral, like Mapisa. But that evidence, I've always said, is very shaky evidence and very doubtful evidence. I don't think on the basis of that evidence, if Mapisa does not come forward to come and incriminate himself, right? Let us say that was the only evidence on record. And perhaps Mapisa, because Mapisa still has the option not to testify in court. If this was the only evidence and Mapisa then decides, because an accused person is under no obligation to prove his innocence, Mapisa can always exercise, his prerogative of, not entering that witness box. and testify. With this kind of evidence at his disposal, would Judge Ratha return a verdict of guilt, and not only guilt but guilty of the crime of murder? So it is on that basis that I think that this decision must be challenged, because I am of the firm view that of all the accused persons, and I'm not writing off anything or taking away anything from any of the other accused persons, but viewed realistically, Mapisa probably stands the best possible chance, right, of getting an acquittal in this matter. So this decision must be challenged. That is my position. And you see, that will begin with Judge Ratha consolidating that judgment that he never wrote down. He will have to come up with a written judgment, and that written judgment must be exactly the sort of judgment that he was speaking about in court. He must come up with a written judgment based on the same facts, and on the same, logic of reasoning that he adopted yesterday. And once the defense are in possession of that written judgment, I think they can then take the matter forward. Because I'm of the firm view that, like I said in my opener, another court might well come to a different decision on whether or not, at that particular point in time, there's a case for Mapisa to answer. Because in his judgment or in his rejection of that application, Judge Ratha does not come out clearly. This is what I was saying. That decision or that ruling yesterday was a bit confusing. You see, he should have come out quite clearly and explicitly to say that these are some of the issues that warrant that Mapisa must get into that witness box to come and clear up. But like I said, the whole thing was done rather informally and was frankly, and with all due respect to the judge, a bit chaotic. So that is my take this morning. This decision must be appealed, and the prospects of its success on appeal are fairly good. Thank you very much.